Good morning. Are you Justice Joanna Lewis?
Yes, ma'am.
And this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have your stay asked you.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right, Mr. Parker, you may proceed.
Your Honor, just first like to point out she has no new cases. Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to the infirmary, the jail. And I believe she did have issues. She was in a wreck, and I can tell you, she's acknowledged to me that she's told me the right things, which was promising, that she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to. She also acknowledges, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take, and that she will be able to complete her probation. I'm asking the court to put her on a high medium caseload, and see if she does what she says she can do. If she's on her medication, and we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing a community service. They're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she'd like to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you're supposed to do the first time.
I got in a car accident, but like I said, I'm not using it as an excuse. But I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it. And I've been taking my medicine. I've been doing everything that I'm supposed to, and I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
Should have reported.
And you should have communicated with them.
I should have communicated, especially with my probation officer.
Mr. Coleman?
I don't have much to offer, Judge. Saying things and making representations, they're easy to do and easy to say, but it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in Spindletop to get those mental health, mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that. And when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue, and she actually is taking medication for these problems, it may help her, and she may have a better chance.
So I'm looking back at the original pre-sentence report from 2024.
Mm-hmm.
And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the pre-sentence report, that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered at in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, I mean, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Miss Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't.
Yeah.
So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with Spindletop, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand?
Yes, ma'am.
So this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need because you'll be given that opportunity. Okay.
Yes, ma'am.
All right. Good luck to you.
Thank you.
Thanks, Judge.
This case is a powerful reminder that a courtroom is not just a place for punishment. It's also a place where accountability and opportunity can exist side by side. Joanna Lewis stood before the judge after admitting multiple probation violations. She had failed to report, failed to follow through with required programs, and gave explanations involving a serious car accident, transportation problems, and ongoing mental health struggles. The prosecution argued that her actions showed a pattern of failure and that giving her another chance would simply repeat the same cycle. Her defense attorney, however, acknowledged her mistakes while emphasizing something equally important. She had begun taking medication, her mental health issues had finally been confirmed, and she was showing genuine willingness to change. The judge carefully considered both perspectives. Rather than ignoring the violations or imposing immediate incarceration, the court looked beyond the paperwork and focused on the root causes behind her repeated failures. What makes this hearing especially significant is that the judge drew a clear line between excuses and accountability. Mental health challenges can be real, and they deserve treatment, but they do not eliminate personal responsibility. The judge recognized that simply telling someone to seek help had not worked in the past. So instead of giving another empty warning, the court ordered a structured special needs treatment program designed to address both mental health and substance abuse issues. It was a decision based on rehabilitation rather than blind leniency. At the same time, the judge made it unmistakably clear that this was not an unlimited supply of second chances. The message was simple. The court would provide every available tool for success, but from this point forward, the responsibility would rest entirely on the defendant to use those tools. This hearing also highlights an important reality about probation that many people misunderstand. Probation is not simply a way to avoid jail. It is a legal commitment that requires consistent communication, compliance with court orders, and personal effort. Missing appointments, ignoring required treatment, or failing to report can be just as serious as committing a new offense because they demonstrate a failure to honor the court's trust. In this case, the judge acknowledged that Joanna Lewis had very little criminal history and believed there was still potential for rehabilitation. That belief ultimately made the difference between another opportunity and a prison sentence. The biggest lesson from this courtroom moment extends far beyond one defendant. Real change begins when someone stops making promises and starts taking action. Words alone cannot rebuild credibility. Only consistent behavior can. The judge's final decision reflected both compassion and firmness. A willingness to invest in someone's recovery while making it clear that future failures would carry much harsher consequences. Justice is often portrayed as either punishment or mercy, but this hearing demonstrates that it can be both. The court offered help, structure, and hope, but it also demanded responsibility in return. Whether this second chance becomes a turning point or a missed opportunity is now entirely in Joanna Lewis's hands.